everyone, we are back today for another trust and estate quick tip. So today we're going to talk about your existing documents that you may have created or executed outside of the state of Florida when you live someplace else. So the question is, are they valid here in Florida? And typically the answer is yes, they are valid here as long as they were validly executed wherever you created them. They are valid in Florida. However, sometimes there are a couple of problems that can arise, and the three most common documents that this happens with is one, a will. So in order to be valid in Florida, a will is typically signed by two people and notarized. Well, let me back up. It needs to be witnessed by two people. It doesn't have to be notarized, but that's where the problem kicks in. If it's not what we call here self-proved, which is the notary part, that's where things can get a little challenging in court. So it's always a good idea to have a Florida attorney review your will and make sure that it's not going to cause any problems. Also, holographic wills are not valid in Florida, but they are valid in other states. And a holographic will means that it is handwritten but not witnessed by two witnesses. So it could be handwritten and witnessed by two witnesses, and that would be valid in Florida. So that would not be considered a holographic will. The other two documents are powers of attorney. So the power of attorney may be valid here in Florida, but if you want to use it for real estate purposes, which is oftentimes very important, it must be executed the same way we would execute a deed in Florida, which requires two witnesses and a notary. Lately, I have been seeing a lot of powers of attorney executed in other states that are notarized only and not witnessed. So definitely have a Florida attorney review your durable power of attorney. And last but not least, pre and post nuptial agreements. The one important thing I have seen happen in these is that they don't reference waivers of homestead. Homestead is a really tricky little thing in Florida, and it's very special to Florida. So your pre or post nup may be perfectly valid, but if it doesn't reference homestead, you could definitely run into a problem, a big, important, expensive, serious problem. So definitely have somebody take a look at that if you move to Florida. That's it. If anybody has any questions about anything I just discussed, feel free to reach out to us at any time.